Welcome to another episode of CTAC Hong Kong Arbitration Center mini lectures. This week, we have the topic of how to manage expert evidence. Expert evidence, or rather, expert witnesses, are commonly introduced at cases administered by CTAC Hong Kong Arbitration Center. Therefore, we find it quite fitting to have one of our guest speakers, Mr. Damien McDonald, to talk about his reflections and how to practice on this matter. Damien, as many of you may have already known, is a barrister and arbitrator at Prince's Chamberss in Hong Kong. He will speak on the implications for practice in light of the PwC and Queen Mary study on the damages awards in international commercial arbitration. He will also discuss the common criticism received from tribunals on damages claims and suggest improvements to be made to the process of instructing experts on the factual foundation for these claims. Please enjoy.
Thank you very much indeed, Brad. I am very pleased to be invited to give a talk on the topic of managing expert evidence, the fundamentals of process and preparation. So, good morning, good afternoon, and good evening to everyone, as and when you have an opportunity in your busy schedule to sit down and watch this short talk. So today's talk is on managing expert evidence. It aims to deal with one very important aspect of expert evidence. In fact, probably the most important apart from the selection of an appropriate witness, namely the preparation of the facts on which the expert witness is instructed to provide his or her opinion. Now, the reason that I thought a talk on this topic was timely was in light of the report by PwC and Queen Mary University released in December last year. I will talk about this report in a bit more detail in a moment, but the report was looking at damages awards in ICC arbitrations. And for present purposes, one of its main conclusions to note was that in many cases, claims for damages and therefore the expert reports in support of those claims were not properly supported by evidence, or that in those expert reports, the underlying assumptions were wrong or unconvincing. Now, all of those points, well, those two key points stem from the preparation of facts in support of a claim. So pausing here for a moment, there are many possible reasons that reports are not properly supported by evidence. The obvious one is that there is no or insufficient evidence in support of the expert opinion. The other one, and perhaps the more charitable one in light of the report and practice in general, is that there must be genuine evidence for many of these claims. But for some reason, these claims are falling down because the factual basis has not been properly collected, sorted, analysed, and presented in an appropriate form for the tribunal to understand the factual basis on which the expert provides his or her opinion. So in this second scenario, assuming that there are sufficient facts, I would suggest that this may be a problem with the process of instructing the expert on the factual evidential foundation. So the basic points flowing from these two observations are that genuine claims should not fail or be reduced because their evidential basis is unclear. And secondly, claims that are genuinely speculative, unsupportive, and unsupportable should simply not be made. That's not a difficult point. The question is why those claims continue to be made. I would suggest that the key reason is because the underlying process is not being properly undertaken so that these issues can be seen sooner by the client and the experts, and the problems with the evidence fixed, clarified, and sorted out, or those claims that don't have a proper basis simply dropped, and the time and money invested elsewhere. So this talk is therefore centered around a discussion on the foundations of expert evidence. It suggests a framework and process for instructing experts. If this process is properly and faithfully put into place, then expert reports and claims should be less likely to be rejected for lack of evidence. Conversely, those reports that have no substance should be identified earlier and abandoned for the sake of the client and everyone involved. Now, moving on to the report itself, it was released, as I said, late last year in December. The link to the report is up on the screen, but a quick internet search will quickly identify it. The sample size is, I would suggest, very significant, with a survey of some 180 ICC awards across 284 separate heads of claim, including counterclaims. The range of claims, as you can see, was from the very modest 2,000 through to the very grand 4 billion, with a medium range of 1.2 million US dollars. Just briefly, here is the figure on the spread of industries, because I think this is important. You'll see that this is broadly similar to to the spread of industries in Asia, probably with the exception of consumer, which at present does not figure largely in this region, if at all. Again, just briefly, I thought it would also be important to show the geographical spread of the parties to those arbitrations which were part of the study. This has more Western parties. This may of course be because the wards studied were those out of Paris and New York. So just pausing here, based on the last few slides, I think the report fairly represents a very good snapshot of international arbitration practice, and where certain aspects are falling down, and is therefore a real reason to treat the report's conclusions and observations seriously. The authors are, of course, PwC and Queen Mary. So these are the leaders in the field. It's a real report based on genuine detailed study, and I would submit very important in terms of reflecting how we're doing things as an industry. Now, the key relevant conclusion, and probably the reason that I wanted to do this talk, is on this slide. Thinking about my introduction, I've labelled it a significant problem with process. So just to read it out, so we, PwC and Queen Mary, observed in this study that claimants very frequently come under criticism from tribunals for their approach to quantifying loss. By far the most common criticism is lack of evidence or an inadequate substantiation of damages claims, followed by wrong or unconvincing underlying assumptions or speculative claims. So this conclusion speaks for itself in that the factual foundation of the expert reports, i.e. those quantifying the loss, was clearly severely lacking. Now, I suspect that the reason for this was process for the points that I put out in the introduction. One, the evidence was not properly put together. Two, the fundamentally bad claim was not recognised and halted at an earlier stage. So now figure 11 of the report shows that in the cases where these criticisms were made by the tribunal, the claimant's overall success was lower than the average success rate of 55% for all awards in the study, which I think in itself is not a great success rate for claims, possibly a point for a further talk or study. But in this study, cases that were subject to the first, second, and third criticism, you can see that the claimants achieved considerably less than the average percentage of the claim awarded. Now, just briefly, the next figure shows the problem in more detail. The first two relate to the quality of the preparation of the factual foundation of the report and the support for any assumptions on relevant and supported facts. The other criticisms such as errors, lack of detail, double counting, inconsistencies, etc., may also very well relate to factual foundation, but they also relate to the process of attention to detail and checking and double checking, which if you give yourself enough time and the experts involved asking lots of questions, then these issues shouldn't be arising, and they shouldn't be, sometimes they do. Practice is difficult, and issues sometimes do arise, but discounts based on these reasons shouldn't really be arising if you can fix them in the process and working better as a team. Well, not as a team, but working together within the process of client, counsel, and independent expert. So about to move into the second half of the talk, but I thought I would insert a slide on the importance of the criteria and how to select an expert witness. Now, the slide on the left, everybody will understand the different engineering, accounting, legal, and other specialities and disciplines that make up the world of expert evidence, so I won't spend any time on that. What I would say in terms of the criteria, my shopping list would always be genuine expertise in the chosen field. This needs to be looked at critically, but this is obviously a fundamental for any expert report. Points 2 and 4, I think, are also very important. But experience in writing properly reasoned, supported expert reports is also fundamental. You need an expert who can actually undertake the work at a sophisticated and independent level based on the information that you are putting up for them as the factual foundation for their report. I think this is critical. Experienced professional experts can and should write their own reports and should be very autonomous and very independent. There are different scenarios where an expert has never done this before, in which case counsel has more of a role, but you still need to be independent and understand that in the end it's their report. Again, probably a topic for another talk, but not this one. Reputation goes without saying, but I would emphasize experience in testifying in court or arbitration. Look, I think if possible, you need somebody who's done this before, preferably at the advanced and international level, either in court or arbitration. They need to know how to explain their report, defend their report, deal with opposing expert witnesses, be cross-examined, deal with questions for the tribunal, gain the trust and persuade the tribunal that they are independent and their evidence should be accepted on the basis that they are independent and their evidence should be accepted. There's no ambiguity here. You need an expert who understands his position and can work with you in getting the right facts and then going ahead and working with the tools that you've given them. So enough on that. In the time available, just looking at the foundations of expert evidence. So there's three circles here. The first area is the expert's opinion. It will be based wholly on the application of the expert's knowledge to the particular facts and evidence in this case. In some cases, the expert will rely on aspects of his or her own direct knowledge. For example, in accounting evidence, some experts may rely on their own specific industry knowledge or direct knowledge of comparable transactions. That's fine. This should, however, be made very clear and set out in the report. The second two circles reflect that the expert opinion must be based on accepted or assumed facts. Some of these facts will be subject to contest within the arbitration, but all of this should be set out very clearly. So those facts must be sourced from the materials before the tribunal, so in the arbitration, and must themselves be proved. So based on a witness statement or a documentary exhibit. In the case of assumption, those assumptions must be clearly identified and based on witness statements, other expert reports, documentary evidence, other material such as industry reports, and so on. Key point is it must be clearly identified and available to the other side to examine and understand how you put the evidence together, how the witnesses put the evidence together, and understand the basis of that evidence. So in some cases, these assumptions will be based on instructions from counsel. For an example, an easy one is an assumption that the date of breach of contract or termination of the contract will be date X. This will obviously be a type of fact that will be subject to determination by the tribunal. If the tribunal was to rule on a different date, then the calculation would obviously be revised. Finally, I would suggest it is good practice to set out the facts, evidence, and assumptions in the expert report and in all drafts so that you can keep track on what they are and how and why the expert is coming to their conclusions in the internal phase before it gets finalised and then published and submitted in the arbitration. Now, this approach is consistent with the FCIArb protocol on expert witnesses and also the IBA rules on evidence. Although they don't expressly refer to assumptions, I think a fair view is that you should set out your assumptions. And in any event, it's good practice in international arbitration and what's expected in the leading common law jurisdictions around the world in any event. So looking at the process, I'm sort of watching the time here. I think it's important we go through this though, because it's the basis of the talk. So this is the process that should be followed when instructing an expert. I've put it at a relatively high level, but it sets out the information flow and the looping back for discussion and confirmation of the facts and verifications of assumptions. This is so that the factual foundation can be properly presented as evidence and traced back to its source and then verified. Now, let's use the example of expert reports on damages because this aligns with the Queen Mary report. So the client will give the instruction and basic evidence to the lawyer, who will in turn put together the legal framework for the claim to give to the expert. The expert may, in many cases, have a role in the selection of the appropriate method of valuation. In this case, let's assume that the expert is quantifying the damages using DCF or discounted cash flow methodology. It is very common, so it's a good basis for the example. Now, this model will be based extensively on the historical accounting records of the company, and in particular, past revenues and costs where available. Obviously, in some cases where the breach has made the company or the asset unable to produce any revenue, then those records won't exist. That's a topic maybe for another lecture. But the model will also look at the projections and forecasts. This is a very complex topic, but in the context of the process, I just wanted to emphasize the critical role of the lawyer in getting this information together with the help of the client and putting it into a coherent and verifiable package for the accountant to look at. Now, as the diagram shows, there will be lots of looping back for questions and clarifications by both the lawyers, but also the expert, actually fundamentally coming back from the expert. The questions could be as simple as looking for missing invoices or information about the progress of major injections of income. So for example, a payout on an insurance claim or otherwise. The list is endless, but it will obviously depend on the facts of each case. So the critical point here, I think, is that all the relevant questions should be both asked and answered. The important point is if there is a gap and it's not filled or explained, it will be an area of attack by the opposing witness and counsel as being unsupported and may ultimately result in the tribunal doubting or discarding this aspect of the evidence, i.e. it'll be subject to the criticism in the PwC report. At a more complex level, in some cases, of course, the documents won't tell the entire picture. This could, for example, relate to how various estimates or revenue or costs were put together. In this case, you will need to, counsel aspect of the audience, will need to recognize this as an issue and then work to get together with an appropriately placed company witness to fill this gap with their evidence and contemporaneous documents explaining how this particular aspect of the accounting was dealt with. So the upshot should be that if this process properly followed through to the end, where everything is understood, everything is clear in terms of where it comes from, and properly identified in the report, then there should be a very clear basis on which to assess the strength of the claim. In other words, bad claims shouldn't get this far. Good claims should be buttressed and supported by the client, lawyer, and expert working together to make sure that the factual evidence is properly presented. So I have second last slide, and I'm slightly over time, but I hope Brad will forgive me. So the David Rifkin quote here is, if the tribunal loses confidence in the expert's view of even a few issues, it will cause them to question her opinion on other issues. That simply makes the last point that I was talking about in terms of not leaving areas of the report open for attack by the other side because questions are left unanswered and documents don't support aspects of the expert evidence. So in arbitration, as claimants counsel, we put up good evidence. The other side will do everything they can to discredit our evidence and vice versa. This is our job and this is part of the process. It's about ensuring that the evidence is tested and only good evidence is put up on which the tribunal can rely and make determinations as to the parties' rights and damages. So in conclusion, I think these are the points. The foundation of successful expert evidence is facts. Counsel is in control of the collection and communication of the facts to the expert witness and testing any assumptions on those facts. If the facts are not correctly communicated to the witness in a clear, controlled, focused, and verifiable manner, and represented as such in the expert report, then there is a real risk that the tribunal will conclude the claim lacks proper evidence or that the relevant assumptions are not supported. The adoption of a disciplined process to collect, communicate, and test the factual evidence can mitigate the risk of expert evidence and the claims being rejected. So with that, that's the end of the talk. Thank you very much to everybody who's stayed to the end of the lecture, and I hope it's been at least interesting in terms of reflecting upon how either you do things, though I expect not, or how the other side do things, and a point for reflection on practice. Thank you to CTAC, of course, for giving me the opportunity to give this talk. I look forward to travel opening up again so that I can get to see everyone again in person and, of course, meet new people in person as well. So thank you very much for your attention indeed, and I look forward to seeing everyone in due course. Okay, bye-bye.